Hey everybody, welcome back to the Court of Random Opinion. My name is Neidigh. I have another quick update for you in the Justin Baldoni versus Blake Lively universe, as I like to call it. We're going to go over this new court filing. It is actually a motion for an extension of time, but in that letter, the lawyers for Justin Baldoni and the Wayfarer parties are expressing to the judge how Blake Lively and Leslie Sloane's parties are being unreasonable and unreasonably refusing professional courtesy. Bruce, unfortunately, no motions to compel lunch yet, but hey, the day is young, I guess. All right. We won't wait too long. We'll get right into it in a second here. I already got it pulled up, but I just want to give people a second to filter in if they want to join us. So we'll wait 1 minute. How about that? Hey, everybody. Natalie, hey, Sheebs. Large Rainier, what's up? All right. And keep in mind, we have a filing due tomorrow and a filing due Friday as well. So there's, there should be some more stuff going on this week. Ryan Reynolds' response was actually due today, but he filed it last night. If you missed that, go to the live stream tabs on my channel, and you can see the long version and the short version of that. So, Natalie, Lauren, do you ever sleep? No. No, I do. It's just I work during the day, so it's not like I could be asleep right now, Okay, let's get into it. Dear Judge, we represent Wayfarer, Justin, etc. In accordance with Rule 1D? Rule 1D? Rule 1D, I'm going to say, of your Honor's individual practices in civil cases, the Wayfarer parties respectfully request an extension of time for all parties, that would include Blake and all of them, to A, respond to the interrogatories served by their respective adversaries, and B, move to amend their pleadings or to join other parties. Okay. So they want an extension of time to file a motion to amend, I guess? Or to join other parties? Okay. No previous request for an extension of time has been made with respect to these items. On March 14th, all parties, except for the New York Times, for whom discovery is stayed, served their respective sets of interrogatories. Pursuant to Federal Rule of Civil Procedure 33b2, answers and objections to the interrogatories are due within 30 days of service or by April 14th, 2025, and that's Monday, I think. In the aggregate, the Wayfarer parties were served with 31 different sets of interrogatories from Blake Lively, Ryan Reynolds, collectively the Lively parties, Leslie Sloane, and Vision PR. Okay. Together, the Lively and Sloane parties have served nearly 1,600 requests for production. Oh my God. I don't know if that, I don't know, because I have nothing to reference it to. It sounds like a lot, but I have nothing to reference it to, so maybe it's not that bad. I don't know. Somebody tell me. And 179 interrogatories, an excessive number of discovery demands to which the Wayfarer parties have been diligently preparing responses. Setting aside the obvious yet troubling implication that the Lively and Sloane parties do not actually know what they are looking for, the Wayfarer parties have already responded in good faith to more than 500 such requests, with hundreds of additional responses expected in short order. Wow. Given that the Wayfarer parties and others have been engaged in extensive briefing in the past few weeks in connection with the motions to dismiss, and given that all parties, save for the New York Times Company, served their discovery requests virtually simultaneously, the Wayfarer parties proposed a mutual extension from April 14th to May 14th for the parties to respond to any interrogatories served upon them. The Lively and Sloane parties refused to consent, and none provided any reason for their refusal. Okay, wow. Bruce says, I don't even have 1,600 things in my house. All right. The Wayfarer parties also sought consent to an extension of the case management plan and scheduling orders April 18th, 2025 deadline to move to amend. The Wayfarer parties explained that it is unlikely that the court will rule on all 4 pending motions to dismiss by April 18th, which is end of next week, I think, especially given that Lively's motion to dismiss will not be fully briefed until April 10th, which is tomorrow. In their papers submitted in opposition to the various dismissal motions, the Wayfarer parties have indicated their intention to move to amend their pleadings if the court is inclined to dismiss any of their claims. Requiring the Wayfarer parties to file their motion to amend by April 18th, 2025, when the dismissal motions are still pending and without guidance from the court as to whether an amended pleading is even warranted, will result in a waste of party and judicial resources. A modest extension of this deadline is sure to sharpen the pleadings and narrow the contested issues before this court, minimizing or even eliminating the need for further motion practice. So remember also, I'm remembering that Brian Friedman had to file a letter to the judge because Blake and her parties were refusing to allow an extension even when they were being affected by the California wildfires. So, wow, I guess they're still playing that game. The Wayfarer parties proposed an extension of the deadline to move to amend from April 18th, 2025 to a date 21 days after the court's last issued ruling on the pending dismissal motions. The New York Times Company has no objection to the foregoing extension, but stated its intention to oppose any motion to amend. Well, yeah, of course. The Sloane parties objected without providing a reason. The Lively parties objected because the April 18th deadline is not dependent on the timing of the court's order on the motions to dismiss. The Wayfarer parties are aware that the deadline for moving to amend is not synchronized with the determination of the dismissal motions, which is why the Wayfarer parties proposed that any motion to amend not be due until after the dismissal motions have been resolved. Given the Lively and Sloane parties' unreasonable refusal to agree to mutual professional courtesies, none of which would prejudice any party, the Wayfarer parties respectfully request that the court A, extend the deadline for the parties to respond to the interrogatory served upon them to May 14, 2025, and B, extend the deadline for the parties to move to amend their pleadings or to join other parties until 21 days after the court has issued a ruling on all pending dismissal motions. The parties' next appearance is scheduled for October 21st, 2025 at 10 a.m. That's their next scheduling, or not scheduling conference, but a conference. Status conference. Okay. And the footnote here, number 1, says, and it's on this sentence right here, the unreasonable refusal to agree to mutual professional courtesies. The footnote says, counsel are expected to cooperate with each other, consistent with the interests of their clients in all phases of the discovery process, and to be courteous in their dealings with each other, including in matters relating to scheduling and timing of various discovery procedures. And I don't really want to hear out of Blake Lively's side any kind of sass in that regard, because they got, what was it, at least a month or maybe close to a month as far as their extension in the Jed Wallace case. And then they took advantage of that opportunity to dump 802 pages on the court while exposing Jed Wallace's medical information, which had been rightfully protected by this court. So, wow. That's a big yikes. P. Mahone, what's going on? Collectively known as Satan's Hand Puppets. No, Emily, we can't change the Lively parties to Satan's Hand Puppets because that is the name of my band. So, all right. Guys, like I said, it was a short one, but it was pretty interesting. So I'll keep you updated on anything else that might come out today. I'm not expecting anything else until tomorrow, though, so we'll see. Thank you for joining me. Don't forget to hit the like button, and I'll see you next time.